The Major Question Doctrine says that when courts review issues of administrative law, they should start with the assumption that federal agencies do not have the power to make rules that have politically or economically significant implications, unless they've been given clear congressional authorization. Over the last several years, several COVID-19 policies have resulted in lawsuits raising important questions about agency power. And in a recent series of cases, the Supreme Court has used the Major Questions Doctrine to rein in the power of executive agencies. For example, the court blocked OSHA's attempt to impose a COVID-19 test or vaccine mandate on large employers. And it also vacated the stay of an injunction on the CDC's COVID-19 nationwide eviction moratorium. In both cases, the court reviewed the agency's authorizing statute and determined that they did not allow regulation on matters of great economic and political significance. In West Virginia versus EPA, the court returned to the doctrine to evaluate the Clean Air Act and the Obama-era Clean Power Plan. Writing for the court, Chief Justice Roberts posited that Congress intends to make major policy decisions itself, not leave those decisions to agencies. He continued, something more than a merely plausible textual basis for the agency action is necessary. The agency instead must point to clear congressional authorization for the power it claims. Taken together, these passages propose a two-step process for courts to evaluate administrative authority. One, does the regulation involve a major question of significant economic or political significance? And two, can the agency point to clear congressional authorization for the regulation? The Major Questions Doctrine is not entirely new. As far back as 2000, Justice O'Connor wrote in FDA versus Brown and Williamson Tobacco Corporation that in extraordinary cases, it could be assumed that Congress did not grant power to an agency to make decisions of huge economic or political significance. The recent applications of the Major Questions Doctrine go beyond this by also requiring clear statutory authority. Supporters of the Major Question Doctrine assert that this is a necessary tool for courts and Congress to rein in administrative agency overreach. As is implicit in the doctrine, some regulations could have an enormous impact on society and the economy, while bypassing the legislative process. Agencies sometimes rely on brief and vague statutes to justify their authority and frequently reinterpret old statutes for new and broader purposes. Some supporters argue that the Major Questions Doctrine could be a way for the Supreme Court to reinvigorate the non-delegation doctrine, which states that the Constitution does not allow Congress to delegate away its legislative power. Critics of the Major Question Doctrine argue that the doctrine is made up, that it has no basis in the Constitution or statutory law, and that it is inconsistent with textualism, the predominant approach the courts use today to interpret statutes. Critics also argue that it remains unclear what qualifies as a major question, which leaves a lot of room for courts to insert their policy preferences when judging. Does the Major Questions Doctrine allow courts to block a president from legitimately enacting policy preferences through agencies? Or is this just a tool to deregulate generally? If important policy issues are not addressed by administrative agencies, will Congress be able to pass legislation to fill the void? And how will new challenges to agency power, citing the Major Questions Doctrine, affect the interpretation of existing statutes and the drafting of new ones? Let us know your thoughts in the comments below.